Ladies and gentlemen, thank you for standing by. Welcome to the BIA Knowledge Leadership webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature located in the left-hand corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this conference is being recorded February 19th, 2015. I would like to now turn the conference over to Ms. Robin Thompson. Please go ahead.
Good afternoon or morning, everyone, depending on which coast you're on, and welcome to the first webinar in our 2015 Knowledge Leadership series of programs. Today's webinar kicks off our 4th year of presenting programs in this series, and the BIA team is so glad to have you here with us today. Before I introduce our speakers, I want to remind everyone of 3 things. First, please send questions through the chat window for our presenters, and any we do not grab in real time, we'll grab at the end of the program. Second, as you exit today, you'll be prompted to answer a very short survey letting us know how we did today and what programs you're most interested in for future webinars in our series. Our programs are developed entirely from your feedback, and we appreciate your attendance and support. Lastly, if you require a certificate of attendance, please write me at edu@biaprotect.com, and I'll be happy to send you one. Now to my favorite part of today's program. Both of our speakers today require little introduction, but if I were to read their formal bios, I would consume most of today's hour. We are honored to have with us Craig Ball, who is a licensed attorney, serves as a court-appointed special master and consultant in computer forensics and e-discovery, is an adjunct professor of e-discovery law at the University of Texas School of Law, and is a nationally sought-after speaker and prolific author on the topic of e-discovery. Alon Israely is also a licensed attorney and holds the distinction of being a certified information systems security professional, who is a co-founding member of BIA and today leads the Strategic Partner Initiative. Alon frequently serves as an expert in cases involving discovery and preservation and is also a frequent author and speaker. And with that, it is my pleasure to turn the program over to Alon.
Alon, before Robin leaves the program for a moment, Robin, could you tell us that email address for CLE again, please?
We give a certificate of attendance, and it is EDU, which is short for education, edu@biaprotect.com.
Thanks.
Yes, sir.
Thanks, Craig. Thanks, Robin. We're actually very happy to have Craig with us on this first webinar of the year and get into a topic that I think continues to be very important. I mean, it has always been important and continues to be important, and I find it interesting with everything that goes on in our industry and all the new technologies and the new methods and everything that's happening. It seems to be that you're always going back to, did you do preservation correctly? Did you issue legal holds? Did you preserve the information? We have the new rules, which really focus on preservation, and I think more and more practitioners and the courts are finding that it's a relatively easy thing for people to do, and it nips a lot of things in the bud for later on. So I'm excited to continue to talk about this topic. I thought what we would do is make this as interactive as we can, and so Craig and I decided to keep it short and not throw 100 slides at you all with bullet points all over the place, but instead give you a little bit of a primer, a little bit of an intro, and then talk to you about kind of what you always want to do and what you always want to think about, what you never want to do and what you never want to think about, and make it more of a discussion around important points. To the extent anyone misses something or has some additional information that they need that we can't get through during the webinar, if you send that same email, the CLE email, edu@biaprotect.com, we'll be able to follow up with you with any answers directly. And with that, let me start by just walking through a few slides and kind of setting the stage, defining the language a little bit. And as attorneys, we love to do that. We always have a 10-page contract, two pages are substantive, and 8 pages are definitions. So I figured it's a good place for us to start. Now, legal hold means a lot of things to a lot of people. Preservation means a lot of things to a lot of people. I many times will hear the term legal hold and preservation intermixed. We're going to define it at a high level, which is you anticipate litigation, and I know there's some discussions around the specific definition of what that means, but in general you anticipate litigation or some legal situation may arise. And so it's really the process of notifying people, whether those are recipients or potential custodians, employees, third parties, notifying them that there is a duty to preserve, that they are going to have to essentially retain information, documents, data, in order to potentially use that later on. But importantly, there is, beyond just the notification side of it, is ensuring that automated IT practices don't inadvertently destroy or alter the data such that it is no longer in that preserved state. And that's a really important part of it, because sometimes we think, let's just tell people, hey, don't delete this stuff, make sure you maintain your email, and then we forget that on the back end, IT doing its job, all those systems, which very much are automated, are potentially purging information based on retention schedules and those kinds of things. So you really want to, that second part is important, is to make sure that those automatic practices, to the extent reasonable, to turn them off or to suspend them in a certain way, that those are done. And then finally, to ensure that the information is actually preserved. This is a step that a lot of people, I think, forget about, or they tend to push off till right before they need to use the information. And what I mean here is that it's very much a good practice to somehow get a copy of information, whether you do the collection or you preserve it in place, or you can somehow ensure that that data that people are notified about needing to preserve is actually in some preserved state. And we'll talk a little bit about how you can do that. But that's really important. So there's 3 main things there, is notifying people of their obligation to preserve, ensuring that those automated IT practices or those housekeeping IT steps are not happening in the background and inadvertently destroying information, and then third, ensuring that you actually do have a set, I call it a lockdown set, a repository of information that you can go to ensure that 10 months after the preservation was supposed to be put in place, 10 months later, a year later, 5 months later, whatever it may be, you have an expensive attorney in court, and they're not wondering where the emails went or where the chat logs went. Now, let's not forget that data is everywhere, especially in today's mobility and workforce. Everybody has information on devices and in the cloud and on servers and on workstations. Even today with thin workstations, a lot of people have machines that they log into, and the machine gets spun up from some cloud service. That's still an area of storage that potentially exists. So you really want to do a lot of thought about where data is kept, and we'll get into this a little bit more, but really think about kind of what are those implicated systems, and be smart about how you do that analysis and how you go about gathering or preserving that information. But this is just that reminder slide that it is in a lot of places these days. Now, Sedona, an important group in our industry, in the legal field, a lot of good best practices and suggestions that are coming out of Sedona. And this is Sedona Principle 5, which really talks about the obligation to preserve ESI, information, data, whatever you want to call it. But ultimately, the real gist here is what is the balance between preserving everything and preserving what it is you need and how you go about doing that. And I know Craig and I have had discussions around this specific issue and balancing that many times in the past. There's a lot of discussion around this among parties and in motion practice, and the more we can really be reasonable about how we go about doing things, I think we're gonna solve a lot of problems. Craig, did you have any comments specifically around the Sedona Principle?
No, I endorse the Sedona Principle. I think that it says what it needs to say, but where I see it being misused is the idea that because perfection is not the standard, anything far removed from perfection is okay, and I think that's the mistake. There's a lot of continuum between doing nothing and doing something that's perfect. We don't see cases where people are being sanctioned for mere imperfection. The vast and overwhelming majority of the cases where we see people being sanctioned for failure to preserve or for spoliation are cases where most of us would look at what they did and say, how could they not have interceded? How could they not have realized they had that email, they had that messaging? How could they not have preserved those documents? Much of what we see is not even close to perfection, but is close to idiotic. So take heart that we're not going to be setting the bar exceedingly high in terms of what is necessary to preserve that which is most relevant. There will be the occasional rare case where something is quite esoteric and the failure to collect it is more contentious. But for the most part, the things we're talking about are fairly plain vanilla. Anybody who'd given it any kind of reasonable thought would have realized that's something we need to hold on to. And that's the only standard that I think both Alon and I will be advocating today.
Yeah, absolutely. And I think that's a really important point to re-clarify and to really kind of give emphasis to. And we tend, maybe as people or as Americans or whatever you want to call it, to go from one extreme to the other. But I think that notion of a spectrum is really key here because I see it too, Craig. Is it's not perfection, and therefore everybody immediately goes to the other pole. There is very much a lot of meat in the middle, so to speak, where most of these things occur. And so I think that's really a good takeaway for everyone. Is it's not going to be perfect, but it can't be 100% not perfect either. There is some place in the middle, and I think it does very much come down to taking a common sense approach, a practical approach, and just being reasonable about how you go about doing things. And to a large extent, that happens early on, and I think we'll talk a little bit about that. It's not something you can do at the last minute and the 11th hour, so to speak.
And you've posed an excellent question here in this slide, Alon. You've said, can a party be sanctioned when it acted reasonably but didn't get it perfect, didn't get it right? And the answer is there is a remote possibility, and there are a tiny, tiny handful of cases where you might look at it and say, gee, that person did everything I would have thought was reasonable, and they were still required to do some of it over or pay some attorney's fees and so forth. What I can say with confidence is that we have not seen any instances, in the last 15 years of anyone having very serious sanctions, dispositive sanctions, serious adverse inference instructions, the kinds of things that really change the course and the outcome of the case, flowing from something that was simply a good faith failure to perfect their preservation. It is simply a case that when you look at the serious sanctions, matters, and decisions, that all of them flow from fairly significant and fairly obvious omissions, some of them, most of them in fact, of a fairly venal and intentional nature, a willful effort on the part of certain parties to make key information go away and to deprive an opponent of that information for fear that it might assist them in litigation.
Yeah, that's a very good point, and you do see that a lot. And a lot of times you see a set of circumstances that leads to that. It's very rarely just one thing, unless it's, like you said, very egregious or intentional. Many times you look at the totality of what happened and you realize, indeed, so many things occurred or enough things happened here where, a reasonable person would have said, wait a minute, guys, you're going to get sanctioned or something's going to go wrong.
And we need to remember that sanctions can feel differently depending upon which side you're on. A court regards a sanction as something that's punitive. They don't generally require the retaking of certain depositions, the reproduction or reprocessing of information as punitive in nature. That is curative. And so they don't think of sanctions as being curative. And that's an important distinction because the law is going to impose a different standard upon a court to order things that are going to make it right, repairing or curative sanctions, versus the standard that's coming into place with the new rules that will govern more intentional or willful activity.
Yeah, that's a great point, and you as a special master, I'm sure, are neck deep into these kinds of things all the time. But I think it's important to note that very, very many times a court will try to take some curative action first before just jumping straight to sanctions, which is punitive. Would you agree with that, Craig? Would you say that more and more the courts are really trying to kind of get the parties to maybe redo a collection or think about how they may have done something in order to cure it before they get down the line of going as far as sanctions?
Oh, unquestionably. One thing I think people don't appreciate is how loath courts are to sanction. Courts are not on the ends of their seats behind the bench just ready to toss the gavel at someone's head. They know that sanctions generally will prompt appeals and challenges, will make people unhappy, can ruin careers, and they don't do that lightly. So, yes, courts are going to work hard to try to get the case back on track, to restore focus on the merits versus discovery disputes where they can, where they have the expertise to know how to do that. But if you are on the receiving end of a court order that requires you to start over, to repay your opponent's attorney's fees for various motions and so forth, it's going to feel like a sanction. It's going to feel like a sanction when you explain it to your client. So even though it's not technically a sanction, the sting is there.
Yeah, that's a great point. And as attorneys and litigators, people who have both that business side where you have to deal with the client, that is really important to think about those things. Whether it's an actual sanction or you have to go describe to the client why it is they're going to have to pay to recollect or something like that, like you said, Craig, that could feel very much the same. And frankly, the client may not care that there is a technical or a nuanced difference between the two if they have to cut another check because of something that may have gone wrong, either because of what they've done or maybe because of what they think they didn't get good advice around. Then yeah, that can get nasty with your client, and that's never a good thing.
Can we talk a little bit about the process by which people should be approaching preservation?
Absolutely, and if we should have the slide up now, which is really kind of what I was talking about a little bit earlier, just kind of clearly spelled out here, which is if you think about these four large areas of process, the process of notifying people, letting people know, telling them what their obligations are, and we'll talk a little bit about how that has to happen and some of the requirements of that are really the best practices. Then there is the second part, which is that kind of identify people, right? Once, a lot of times you'll cast a little bit of a wider net and have certain departments or swaths of people, groups of people told that they may be obligated to retain documents. And then as you do a little bit more homework, a little bit more research, and start to get a better handle on the issues, you start to focus in on who specifically may be custodians or folks that potentially have information that would have to be gathered. And then also, what are the systems that may have to be connected to in order to gather information? It's not just necessarily people that maintain information, but there are systems as well that people interact with that are going to store information, the types of information, the types of data. So these are all important things to consider as you're planning the preservation process. And then there's that third one there, which is ensuring that those automated tasks are managed appropriately. It's not okay to just say, oh, well, I don't know, IT didn't suspend that retention rule. And I could tell you more and more coming from the IT side, especially more and more it is relatively simple and easy for IT to do certain things in order to suspend practices. It's not like it used to be where if you didn't want email retention rules to overwrite inboxes and those kinds of things that you had to take a lot of steps. Today, many times there's admin screens and check boxes that you can use, and a lot of automation, frankly, that you can use in order to ensure that occurs. And then there's that last point, which is ensure that you have a copy of the stuff, ensure that you have it gathered. Too many times I've been in experiences where attorneys or general counsel's office will say, well, we told people not to delete it, and therefore, of course, it's going to be there in 8 months or a year or when we need it, and that's not necessarily the case. And so having some assurances that you have a copy of the stuff, even if it's a more honed set, is going to be very important to the overall process. Did you want to add anything
I agree with
to that?
You on, go ahead. I'm sorry, please.
No, I was going to just ask if you wanted to add anything, Craig. Go ahead.
Well, I've long felt that we need to remember in addressing legal hold. I'm reminded of the words of the legendary Texas football coach Darrell Royal, who's credited with saying that there are 3 things that can happen when you pass a football in a football game, and 2 of them are bad. And that's a bit how I look at advising custodians to be responsible for legal hold, is that, of course, you're going to, if you're fortunate, have the responsible custodian who is going to take a measured and reasonable approach to preservation that will give it the time and the attention. Somehow they will know the tools and keywords and techniques to use to preserve. But I think the more rational expectation is that they will have some who will simply blow it off. They're too busy. It's not their job. It's somebody else's responsibility. They're too important to the company to waste their time, blah, blah, blah. And then you will have the occasional person who, whether their fear goes to the merits of the case or they simply are afraid of something else in their use of computer tools and the scrutiny that will follow, will decide to make things go away to protect themselves. And in that process, 2 out of the 3 things we do when we do a legal hold in a cursory fashion, without a backstop of IT, without appropriate preparation and assurances, as well as instructions to the various custodians, is destined to fail. And so one of the things I wanted to touch on today is that what you've just identified to me, Alon, first of all, it's bulletproof advice, excellent advice. But I would call it to some extent e-discovery 1.0, which is to say it's a proven technique for the e-discovery world that we have seen for the last 10 years or so. But I think it's necessary for us to be thinking about what we might call e-discovery preservation 2.0, which is going to be not preserving by making a copy of the information. I think that we are facing a time where, to the extent that we are hurting ourselves, shooting ourselves in the foot with preservation, we are doing it through over-preservation, the sense often laid at the feet of the lawyers in charge that it's safer to preserve more, so over-preserve. And I think that when we do that by copying, we are inflicting upon ourselves a serious problem, and that is you are creating a static, unchanging snapshot of what you copy, and then you have the information that may still be subject to preservation, moving forward and changing. So you're not really relieving yourself necessarily of the obligation to keep preserving, but now you've created a differing and disparate iteration, largely duplicative of the data that you're going to have to deal with. And so now you have all of these snapshots, and this is where most of the cost of e-discovery comes in, the risk of misinformation, the failure to adapt the snapshot to the right scope, the failure to filter, and so forth. I think we need to be moving in this 2.0 world to in situ preservation, which is systems and mechanisms that allow us to lock the data down where it lives instead of creating yet another copy of that data. And Alon touched on that. I imagine he was probably thinking about the modern email systems today, whether you're using, say, Microsoft Exchange 2013 or other tools, that increasingly IT has the ability to put information on hold in a very defensible, very low-cost way that is largely transparent to the end user. The end user will continue to delete things and clean up their mailboxes and do business as usual, but those activities only appear to the user. In reality, the information, whether through a journaling mechanism, which makes copies of information going in and out of mailboxes, or through another form of preservation, that information is going to stay there as long as it is needed for the legal hold, and you are less dependent upon the individual custodians doing it right that 1 out of 3 times. Let me make one last point before I hand it back to you, Alon, which is that people often ask me, well, which is it, Craig? Do we have the IT do the preservation, or do we have a custodial hold? And the answer necessarily is, well, you need a measure of both. The custodians themselves are subject matter experts. Nobody knows their data like they know their data, and they're ultimately going to be, in many instances, witnesses in the case. So you don't want your witness to be saying, no, I didn't know I was supposed to hold anything, nobody ever sent me anything, etc. Your witnesses are your worst enemies when it comes to recounting their understanding of their preservation obligation. So you want them to be informed, and you want them to be well informed, but you need to protect against their own human foibles and failings by having IT or others provide a safety net of good and reasonably calculated preservation activities. Doing both is not twice as expensive. It's not even that much more expensive, but it will save you a world of hurt when one or the other fails to be adequate alone.
Absolutely, and I would argue actually it's even less expensive to do both, because then you're in that you're in that area of balancing the right way of doing it. And we're going to talk a little bit more about that specific point as we get Craig to your slides and we talk about what you should never be doing. I'd like to touch on a few things. So you and I are on the same page in a lot of things when it comes to this stuff, and this one too. I would say the meta point there is really that you call it 1.0, 2.0. I call it this move into anti-brute force tactics in e-discovery. I feel that for the last decade we've been using brute force tactics in order to preserve information and really do e-discovery across the board, whether you're talking about keyword searching or analytics or any of that stuff. It seems that in the past lawyers have just thrown a ton of technology and a ton of processes and many times get them to a point where you have so much more data than you really need. This notion of over-obligation, we work very much every day with GCs and corporate legal departments, and this is becoming very much a real problem, which is if you have more data than you need and you've preserved that data, then you are now obligated in some sense, or you could potentially be obligated, and the other side could say to you, well, you've got it all. Now it's just maybe a matter of costs or sharing the cost even to determine who's going to actually go through this stuff. So if you look at what's going on kind of with e-discovery 2.0 or anti-brute force tactics, whatever terminology you want to use, and corroborated by what's happening, some of the changes happening in information governance, and focusing on really being able to identify data in the ecosystem of the corporate data world kind of early on, and knowing what you have. All of this goes to being smarter about how you go about gathering information. You definitely don't want to just make copies and copies and copies of the stuff. Some vendors may like that. They charge for essentially normalizing and culling that data down and deduping it. But really what you want to think about is what is the information we need, and how do we go about ensuring that it does not get deleted either inadvertently or intentionally. Sometimes that may mean having to set aside a copy of the data somewhere else. Many times, though, you can leverage existing technologies and relatively inexpensive software and other technologies in order to put yourself in a position where you're not just essentially hoarding the data in some other place for legal purposes, because ultimately what that turns into is an entire other initiative years down the road to figure out how we get rid of all the stuff we don't need. And so if you're smarter about it early on, then that kind of set of data that you've ultimately preserved is likely just what you need in order to prosecute or defend that particular case. So
and as we talk about moving towards, again, I'm not thrilled with my own coinage of 1.0 to 2.0, but the old way and the coming way, Alon, I think we need to recognize one other fundamental change, a real sea change. Not only is the cloud and the emergence of new devices, portable devices, Internet of Things and so forth going to be a point we'll touch on in a moment, but let's talk about structured data for a moment, and that's database data. Few lawyers I encounter have a real appreciation of just how much of the information that we are required to deal with in electronic discovery resides in structured environments. They don't tend to think of email as structured or database data, but of course it is. And any organization of any size is dealing with most of its business operations in one or another form of structured data or database environment. Many companies, large companies, the business itself is essentially a database. So we're talking about something that is extraordinarily dynamic, changing microsecond to microsecond with vast numbers of individual transactions. And so the quaint notion that we're going to, if one were to sue Google, we'll just make a copy of Google's database is nonsense. We are going to have to think more intelligently about how to preserve structured data, whether we are going to be doing fielded exports, that is, keeping the data as data, but moving selected components of the database off into a separate set of data for later analysis and production, whether we are going to be having to snapshot certain aspects of the data, such as by, heaven forbid, setting aside a backup of the data, or, more importantly, whether we can look at the data, make a reasoned judgment about how effective the system is in terms of its ability to roll back to historical information that may be needed in discovery. Many financial databases are designed to do that with ease, and whether we can communicate with an opponent and say, here's what we're going to do, this is reasonable for our systems, and here's what you may not have available as a consequence of this, and put the onus where you can on an opponent to object, to seek protection from the court in terms of how you're going to handle it. Very few people get sanctioned if they've been transparent in what they are going to do and what they aren't going to do, because judges are not really going to protect those who sit on their rights and fail to assert their rights. So even though preservation may come before you have a clearly identified opponent, there are often cases where you can minimize the risk of non-preservation by an appropriate level of transparency and communication.
Absolutely, and I think we hear more and more courts and judges today talking about this notion of cooperation early, and we see this also in some of the new rules, or kind of forcing that cooperation early on, and I think that's a very important point. I would say, it is very much true that it seems to be in our business, at least, we're always focusing on the unstructured stuff, but there's still so many structured systems, and like you said, most of those structured systems are generally critical to running the business. My thought on that, frankly, is leverage the system in and of itself. And so I think a lot of times we tend to think about how can we preserve out of a structured system, and we tend to overlay on that what we do in the unstructured world. Now, I will make the point that mostly we focus on unstructured because that's the wild west of data. That's the harder stuff to get our hands around. The structured data, because it is a contiguous system and it does have a structure, it seems at least that it would be easier to get to, although you make a lot of good points, Craig, in that sometimes these systems get purged and get overwritten, and you want to ensure that to the extent they should not be because of what's going on the legal side, that you have some protections against that. I think one of the things that, when I talk to our clients and the corporations, one of the things we try to do all the time is, with respect to structured systems, say, use a really practical approach. Rely on the system itself. A lot of these systems were built such that you really have never have an operational need to go to the raw back end of it, meaning the front end or the middle, the business logic layer is very important to the operations of the system. And so I say from rediscovery purposes and preservation purposes, leverage that. So for example, if there is a report you can get out of a system that is going to be comprehensive, that's going to give you the real snapshot of the way the data is maintained or the way it's used, I think it's okay to leverage that functionality of the system instead of trying to kind of over-engineer this way of going to the back end and pulling the data out in some way that then has to then get converted anyway for attorneys to use in some, to have use, make use of in a smart way, or in an easy way. So I think that, look at those structured systems and say, how do those structured systems get that data out to me? How do they message the information to me in the normal course of business? Can I leverage that for discovery purposes? And I think if you start to think about structured systems in that way, it becomes very much a different analysis or diagnosis as to how you go about preserving information from those systems.
We are somewhat on the same page, Alon. I agree with you that for the most part, if you can extract information in the forms in which it is used in day-to-day business, the standard reporting capabilities of the database, that is likely to be relevant, likely to be sufficient, with the proviso that data needs to stay data. Moving it into a static PDF, moving it into something that isn't fielded, that doesn't keep the elements of the data separate as they are used in real life, dumbs the data down, makes it significantly less useful. And so I think the ultimate utility of the data, the ability to pull it into comparable databases for analysis, needs to be a factor considered in the form of preservation. Now, let me turn, if I may, to the slide you have up, because it's intriguing to me. Oh, I meant actually the previous one. As we talk about practical steps, I'm catching you by surprise with this, Alon, so I'm going to apologize in advance. But I look at these and I say to myself, are these really practical? Can we, in a modern computing environment, tell people do not delete any files, do not copy any files, do not move any files, and I guess a fourth one would be do not alter files? I mean, pragmatically, in running a business, how can we provide such blanket statements as don't delete, copy, or move files?
Yeah, I mean, what I'll do is I'll answer you with your own suggestions from earlier, which is today's modern systems have a lot of ways of ensuring that data doesn't get deleted outside of the user course. And so, these steps here are really meant to give you a high-level understanding of what you don't want. You don't want to take any affirmative actions to delete files. You don't want to copy files just to copy them to say, now I have a preserved step. So this is really about looking at what it is you need to do in preservation and seeing whether there's a way to do it without actually going the physical steps of copying a file or moving it somewhere else and therefore losing potentially important information. And so if you look at Office 365, if you look at SharePoint and Google Docs and most of the more modern email systems, especially with kind of the standard APIs, the application programming interfaces that they come with, and some of the management tools and some of the configurable tools, the admin packs that you can get, there is a lot, I would argue, 80–90% of what you can do that without actually doing what we used to have to do, which is let me just make a copy of this hard drive, or let me have some custodian move a bunch of files from that share into this folder over here. So that's really what we're trying to message in this slide. But there is very much a lot of ways, especially in modern systems, so that you can preserve information in a standard that will meet all of the legal requirements, but do it without literally just kind of robocopying the stuff or moving it over here. And that's really what we mean by this. I think
it helps to have a couple of concepts. I use a concept I call the Big Four, which is have clearly in your mind what are the things you need to deal with routinely for the plain vanilla day in, day out case. I mean, email is certainly one of the Big Four, relevant database content, custodial shared areas, allocations of space on the network for purposes of backing up work product. I mean, those are some that come to mind. Obviously, loose document storage on devices. These have been the classic big four. We increasingly are going to have to add to that mobile devices, because we have lied to ourselves for a long time that mobile devices are merely a replicant of something else we have elsewhere on the network. And I think increasingly, if that was ever true, it is far from true today. Most of the things we use today, the applications and so forth we use today, exist only on mobile devices and cloud synchronization from mobile devices. So the preservation challenges there are significant, and we have adapted to them largely by putting our heads in the ground as lawyers and just saying, oh, we'll get that from some other source. So the mobile device challenge, and the good news is that by virtue of our reliance upon those devices and increasingly the routine replication of those devices into a cloud source, an iCloud or some other routine backup feature, means that we have fewer places that we will need to go to effectuate preservation. The accumulation of information in the cloud is going to make preservation much easier to achieve at much lower cost. Right now it seems like yet another thing that we have to fool with, but very quickly we're going to find that it becomes the repository of so much as a primary storage area that simply putting a hold on it in the cloud will prove again and again to be a reasonable and defensible approach to preservation.
Yeah, I agree. I think that if you think like an IT person, you really have to think of the device side of things as part of a larger ecosystem of data. And that may not have been true, say, 5 years ago, but there's been, the advent of the cloud and a lot of progress in mobile computing and the way we use data across different devices. I mean, today you buy a new computer and you put in your Live ID or your Apple ID, and before you know it, everything is there and everything is kind of working the way it was on your previous device. And so if you think about it in terms of an ecosystem, then it becomes slightly a different approach. Ultimately, all the rules are the same around preservation, but you don't have to think about everything as this kind of disparate, discrete storage device that somehow you're going to have to string together or thread together later on. So I think that is important. That there are also privacy issues and a whole other host of things that come up when we start to talk about devices, and especially in the workplace. But it is one of the things that I think like you, Craig, that is going to make our life in preservation a little bit easier.
Oh, and I can provide a case in point. Google, to me, is the best case in point. Today, you can go to Google and you can look at an individual, assuming you have credentials, that is. There's virtually no aspect of the information that an individual can store on Google that Google hasn't just made 2 clicks to preservation today. If you want someone's Gmail, whether it be complete or filtered, you can have Google put that Gmail into an mbox format, deliver it to you. It has become extraordinarily easy to preserve in certain aspects of the cloud, so much so that I'm looking forward to people moving to Office 365, moving to the various Google business-related tools, because it's going to make my life, whether as a e-discovery consultant, special master, or forensic examiner, just that much easier. More certainty, less uncertainty in terms of where you need to go, how many different disparate forms need to be preserved, trying to pry that mobile device out of someone's hands when for most of us the level of addiction to those screens is such that we will start sweating if we don't have our phone in our hands for more than about 30 seconds.
Exactly, and we all know that if lawyers have to take away your device in order to do their preservation, it's definitely going to be more than 30 seconds.
More than that, because it's also, I think most people who haven't done preservation of mobile devices don't appreciate that the interfaces are much slower than their counterpart interfaces on a computer. So it can take 10 times longer to download a comparable volume of data from a mobile phone than you would in the speedier approach of downloading it from a local hard drive. That means that, as phones grow, you're talking about depriving people of their phones for hours, possibly overnight, which in this modern world is an untenable prospect for people.
Yeah, and again, that's kind of your point about the cloud and having these synced utilities and devices make it easier. I mean, even on the storage side, Box and OneDrive and all of these cloud, just raw cloud storage systems, they do have syncing mechanisms. So there are ways to get the information in a manner that is, that meets the standards you need to meet, and still assures that you're going to get everything and do it in a way that's not going to burden the custodian or the users. So I mean, there's probably an entire discussion, Craig, on kind of cloud preservation, and maybe that's a good topic for us to do sometime in the near future. I wanted to take.
About
yeah,
that.
Yeah, that'd definitely be fun.
Be nice to have some good news for a while.
Yes. We have the two slides that you put together, and I really love to talk through them. Let's see if we could jump to them now, because we're kind of running short on time. Anytime you and I get together, it goes quick, I think. Let's talk a little bit about what you always want to do and what you never want to do, and I'll let you walk through these, and I may have some comments here and there as you do that.
And I know we have people from a variety of different experience levels on the phone, so for some of you this will seem pretty elementary, but I think it's helpful to have a few hard, fast rules. And so I tried to distill 3 things you always need to do and 3 things that you never want to do in this area. One of them is so obvious. It was so well said by Judge Shinlin. When she came out with the pension committee case a few years back, she made the statement that the failure to put a written legal hold in place was gross negligence. And I think that what was in her mind an effort to state something that was more in the nature of hyperbole or appropriate to the peculiar facts of that difficult case than a new legal test of per se gross negligence. When challenged at it at the Georgetown Institute, Advanced Discovery Institute a couple of years back, she took the position and said, kind of use the Nike, just do it. Just do it. Putting a written legal hold in place is the smart thing to do. Now, I believe, however, that the approach we've taken to legal hold as counsel has been embarrassing. We have this idea that there's some kind of magic word letter. Usually it's a form we've stolen from somebody else, and we change a couple of things, the names of the parties and maybe the name of the case, hopefully the name of the case, and we send this letter around. We send it to IT, we send it to HR, we send it to individual custodians. We just think it's the universal answer, and it's not. It's important that a legal hold be clear, personal, and practical. And let me share what I mean by that. First of all, the hold should be tailored to the role of the person who receives it. I know it seems like extra work to have to do a hold for IT that's different from the hold for custodians, but it's essential to do that. IT deals with information as data, and custodians deal with information as information. IT doesn't care much about content. Custodians don't care much about location of data. So you have to be talking to each with respect to their appropriate roles. If you say to an IT person, preserve everything about this topic, you're making their life impossible because they're not subject matter experts on relevance. They may not be equipped to make substantive division of information. But if you talk about preserving a particular backup, preserving a particular range of dates and custodians and accounts, they're going to know what you want. And you're going to have to speak in very precise languages. Making it personal, I think, is important too, at least with the key custodians. I like to add something to a legal hold that is personal to the recipient. If someone is running HR, I may say, you're going to have personnel applications, disciplinary records, compensation information, whatever is within their ambit. And I like to even write a handwritten note that says, Jane, because of your unique position, we are looking to you to preserve this sort of information particularly. The idea is to remove from the recipient's mind the notion that it's somebody else's problem. Oh, everybody got this letter, so they don't mean me. And I like to make sure that each person understands I mean you, and that you are part of a chain of obligations that must be met in order to protect this company. And practical, which is telling people to do something that is merely aspirational, where they don't really know what it is they're supposed to do. We'll force them to make decisions that we will regret. Oh, this legal hold thing, I just thought it meant I wasn't supposed to go deleting stuff about this, so I made a mental note not to delete stuff about this. Well, in point of fact, we need to tell people what to do, what tools they use to do it, what criteria they use to do it. Otherwise, these legal holds are merely window dressing. We have to train people to understand what this obligation entails. And for the most part, legal hold, as I say, just becomes a form letter that gets sent out to a wide swath of people, and everybody winks at the idea of, I get these all the time, I never do anything about them. That's all fine for the 9 out of 10 cases that don't go to trial. But that 10th case, when that custodian takes the stand and says, I get these things all the time, they're just noise, I never do anything, that's going to blow up, and you don't want to set the stage for that. And the third point is testing. Why don't you, if you have something you'd like to add on that, Alon, before I move on to
Craig, I was just going to quickly say that we have seen more and more the legal hold language be kind of very simple, bulleted, to the extent you are. I think that the personal aspect that you mentioned is awesome. I'm going to start using that advice with my GCs, with some of the folks we work with. But, to the extent they are, they'll come back and say, look, we still have to send out 200 of these or 100 of these. I don't have the ability to make them all personal. I think your point there is the key custodians especially. But to the extent you are sending out 50, 100, 200 of these, I think if you just make them simple in format, you use bullets, you use colloquial or more kind of basic language, not as much legalese, I think that goes a long way in helping clarify what it is custodians need to do. So that's just one of the points I want to make, is kind of just a simple form, really basic language. It doesn't have to be legalese and a bunch of complexity, and I think it'll go farther.
And I think you've done, you're right, of course, if you're doing 200 of these to people who are similarly situated, this is not, your junior league luncheon thank you notes. It's not that everybody has to get a handwritten note, but for certain people, the custodians who, if they mess up, are going to bring down the case, or going to bring you a world of hurt, I think letting them know that they have particularized responsibilities for the it's kind of like when you get those letters and it's, Dear Mr. Israely, and someone has taken the time to cross out Mr. Israely and written Alon in their hand. There's something about that recognition that it's to you personally that changes our response to the communication. Now, it's much harder to do this with e-discovery and legal holds because many of these are coming in a very impersonal electronic form, but we can do it, and we can pair it with a follow-up by phone, a questionnaire, something that reminds people that this isn't merely a winking obligation that we all know we're going to ignore, but this is a genuine need to do something specific. And so let me talk about the third always, and that is testing searches. Now, it may seem that I'm putting the cart before the horse when I talk about searches in the context of preservation. You may be thinking, well, no, wait a second, we don't do searches when we preserve, but in point of fact, we use a variety of different searching techniques, culling techniques throughout the e-discovery process. We can't begin to find things to preserve unless we have used some kind of mechanism of search associated with our information environment. And so I think one of the mistakes we make as we try to make intelligent decisions of what to preserve and what to leave behind is that we rarely test our assumptions about the efficacy of our searches, whether that be we will use a specialized mechanism to only isolate folder structures of a particular name or date range, or we are looking more precisely at particularized custodians, keywords, and so forth, it is never defensible, in my mind, to assume that a keyword is going to produce the results that you hope it will produce until you have run it against a representative sample of the data, you have put eyes on the results, and identified whether it is imprecise or unduly noisy in some fashion that you have tweaked your searches to be defensible. And at every stage, this failure to test against real data is going to be a problem down the line. I know that when I'm challenging what people have done and they say, well, we search for X, Y, and Z, there's always going to be something they didn't search for that will be obvious. And what will protect them is when they can say, we came up, we brainstormed some ideas, we tested it against 2 custodians' representative data, we looked qualitatively at the results, and then that gave us the confidence to deploy our searches more broadly.
That's absolutely true. I mean, this notion is especially poignant for corporations that have multiple matters per year, and you have matter over matter. Many times you can leverage information from a previous matter in order to test for a subsequent one. It is very much always takes a lot less resources to maybe choose a number of custodians, gather their information, or be able to somehow search against their information in order to then help inform the larger strategy. So I think that is something that a lot of people don't think about, Craig, because they think, oh, that's later on in the process. But I agree with you, and there are methods and technologies and systems in place that allow you to do searching early, and that notion of testing them, I think, becomes very important because, frankly, you're standing on a much stronger ground as you go and you pursue the rest of your strategy. We are running out of time, so I want to
say, and
sure.
There's so many always I'd like to put in, but a couple that have come to mind are worth mentioning. Where I see a lot of people get in trouble with preservation is with structured data that has gone through a migration, old databases to new data systems, and either they have not preserved the capabilities of search associated with the old database, or they've made certain assumptions about the migration, poorly documented the migration. So that's an area where you have to realize that IT is going to keep moving forward, and that database that was put on hold may not be reflected in the way you imagine it in its successor. They have to understand that those changes impact the preservation obligation. The other one where people get in Dutch is failing to deal with changes in personnel, especially departing employees. This is one of those things where something as simple as a 2-cent paper label pasted on somebody's laptop that says this device is subject to legal hold, do not retask, do not redeploy without contacting legal, that would have saved such a lot of pain in certain high-profile cases. Because very often IT has a fixed regime for how they will turn off people's email systems, purge their collections, wipe and redeploy their hard drives. That is totally disconnected from the custodial preservation obligation. And let's face it, a departing employee out the door is not most concerned with their former employer's preservation obligations. They've got other things on their mind. So they aren't the person that you can rely upon to say, and oh, by the way, I was put on legal hold 2 years ago. You need to be sure that my laptop doesn't get wiped. Those kinds of simple rules, simple mechanisms you can put in place go a long way in preventing many of the horror stories we've heard of preservation.
Absolutely. We have just a few more minutes. I want to take us to some of the nevers. We also have some case law, which we probably won't get to, but we can send those who are interested. We can send a document listing some of those cases. But Craig, if you mind, just in like a minute and a half here, just talk a little bit about some of these nevers. I think they're very important, kind of other side of the coin.
Well, thank you. And look, I think the world of IT people. I love working with IT people. Learning to speak geek has been one of the great prides of my life as a lawyer. But they don't think the way lawyers think. When a lawyer goes down to IT, the thing that is going through IT's mind is, how do I get this person out of here? I don't want to do what you want me to do. And so it's common for IT to listen to the question and answer it in the way that is least likely to engender new work. So you never accept what IT says without being from Missouri. Show me, push back, challenge that which doesn't sound rational. No, we don't have any email from a year ago. Our policy is we purge it every 6 months. Well, look, everybody knows that whatever your policy to purge is, the reality is going to be different. And you've got to turn the conversation around with IT. You've got to approach them with, it would really be helpful if we had this stuff. Because the lawyer who goes down to IT and says, we don't have any of that old email, do we? Because that's against our policy, is never going to be greeted with, oh, no, we routinely ignore the policy down here because we've saved so many people's tender rear ends because we had something that we weren't supposed to. You're not going to hear that. Yeah. So never accept what IT says at face value, push back on it until you're certain that, A, you fully understand what you've been told, and B, you can stand up in court and defend it. Second, and we've touched on this enough, I won't spend too much time, is that you cannot rely exclusively on custodial hold. You've got to backstop that with a certain amount of objective preservation, usually working with IT, but maybe also imaging drives after hours. It's going to depend upon the nature of case, how much you may have to protect employees from their own tendencies to reinvent history. And the final one, and perhaps no friend to you, Alon, in my making this point, is that we don't want to challenge on things where we aren't fully comfortable as lawyers. And so there's nothing more negotiable than the cost of electronic discovery, particularly when you can provide some sound metrics about the volume and nature of data to your vendor that doesn't require them to build in a lot of protections in the nature of higher per unit costs, because most of the time the lawyers who come to IT don't, or come to vendors, don't really appreciate the nature and scope of the work they're bringing forward. They often trivialize it. It's not a lot of gigabytes without realizing it may be compressed and so forth. And so in order to protect themselves, vendors have to build in higher costs than a more transparent, a more informed system and means of communication would engender. So what the vendor asks for is not necessarily the price you have to pay, and it's important to remember that.
And I would agree with you. And I think kind of the meta points, the three kind of takeaways here is, coordinate with IT, make them a part of the process. To the extent you can, even potentially learn about what happens early so that you're well organized beforehand. Two, don't rely just on custodians to ensure that they've collected and held. They should be a part of the designation process, the identification process, but you really do have to balance that with other back-end approaches. And then, make sure that you're working with vendors that will ensure pricing predictability, manage budgets, clear scope. You really, in today's e-discovery environment, there's a lot of fixed fees that you can do, and so I would urge everyone to talk to their vendors about going in that direction as opposed to kind of e-discovery circa 2002. Well, we are out of time. We just have a few minutes. Craig, I don't know if you want to spend just 30 seconds kind of closing up. We will get, those of you who want, we have some case law we were going to try to get to, and we'll make sure to send not only this short list, but even a longer list for those folks who want it. But Craig, why don't you go ahead and wrap up in the next 20 seconds or so, and then we'll hand it off to Robin.
I will say this, the more you know about data as an attorney, as a litigation support professional, the less preservation costs, because what is lacking is the ability to make defensible choices in what must be preserved and what can be left behind. And as I say, the more you know, the less it costs.
Yep, good point. Robin?
Gentlemen, thank you so much for participating in this month's program. We're about 5 past the hour. I want to thank all of you who attended today. You can find the roster of our programs at www.biaprotect.com at the education page. As always, our programs are presented complimentary. Thank you to Craig Ball and Alon Israely for your valuable time.
Pleasure. Thanks for having me.
Our pleasure. Yes. Thanks, Robin.